Thank you, President. Caribbean Court of Justice, Appellate Jurisdiction, on appeal from the Court of Appeal of Belize. Judgment delivery in BZCV number 2019 between Waitress Corporate Services Limited and Acosta Longsworth. Just to comprise their honors, Mr. Justice Saunders, President and Presiding Judge.
Good morning, Council. We're getting some feedback. I'm not sure from. That stopped it. You're on mute, Madam Deputy Registrar.
Today's panel comprised Mr. Justice Saunders, President and the Presiding Judge.
Good morning again, Council.
Mr. Justice Anderson.
Good morning, Council.
Madam Justice Rajnath Lee. And Mr. Justice Jamada.
Good morning, Council.
May we have the appearances, please? Thank you.
For the appellant, Rodwell Williams, and with me is Ms. Lisette Steen and Mr. Adler Waite.
Naima Barrow for Karen Acosta Longsworth.
Thank you, Council. The judgment in this matter was a unanimous one. It was authored by Madam Justice Rajnath Lee and Mr. Justice Burgess. Mr. Justice Burgess is not here with us today, but obviously he concurs in the result. And I'm going to ask Madam Justice Rajnath Lee to read a summary of the court's judgment.
Thank you very much, President. This summary is not intended to be a substitute for the reasons of the Caribbean Court of Justice or to be used in any later consideration of the court's reasons. The appellant, Bay Trust Corporate Services Limited, the company or BTCSL, and the respondent, Karen Acosta Longsworth, Miss Longsworth, we refer to her as, raised before the Caribbean Court of Justice, the court, two important issues. One, whether the conduct of Mr. Wilson, Mr. Glen Wilson, who we refer to in this summary as Mr. Wilson, the chairman president of the company, could amount to constructive dismissal of Ms. Longsworth. And two, whether the conduct of Mr. Wilson could be attributed to the company. The court, in its judgment delivered by Justices Rajnath Lee and Burgess, determined these issues in the affirmative. On the 1st of February 2002, Bay Trust International Limited, BTIL, was incorporated in Belize to carry on business as an international financial services provider. By a contract of employment dated 28th January 2002, Ms. Longsworth was employed to manage BTIL. In keeping with the terms of the contract, she was appointed a director of BTIL in 2002. Between 2002 and 2010, Ms. Longsworth was issued shares, eventually resulting in her holding 30% of BTCSL's shareholding, with Mr. Wilson holding 70%. Although the factual circumstances surrounding the incorporation of BTIL and BTCSL are unclear, the court was satisfied that BTCSL has not contended that Ms. Longsworth sued the wrong party. This matter contains a significant number of background events extending from 2010 to 2011. These include numerous exchanges between Mr. Wilson and Ms. Longsworth, largely chronicled by extensive email correspondence. Ms. Longsworth alleged that from around October 2010, The relationship between her and Mr. Wilson began to deteriorate. Despite this, however, on the 3rd of January 2011, Ms. Longsworth signed a supplemental written agreement with BTCSL to continue in its employment as managing director for an additional period of 5 years. As the trial judge noted, the email evidence before her revealed that around March to July 2011, disagreements erupted continuously between Mr. Wilson and Ms. Longsworth. Their relationship disintegrated to the point where there were shouting matches between them in the workplace and in front of staff. On the 27th of June 2011, she emailed him complaining that he had repeatedly embarrassed and belittled her in front of staff. She called upon him to desist from obstructing her management of the company. On 9th July 2011, Mr. Wilson replied that he had every right to involve himself in company matters. It was against this volatile background that on the 16th of July 2011, Mr. Wilson sent an email to Ms. Longsworth regarding the future management of BTCSL and BTIL. In the attachment in the email entitled The Way Forward, Mr. Wilson indicated that in his capacity as majority shareholder and chairman, president of both BTCSL and BTIL, he had taken over the management of both companies. The attachment contained, among other things, a detailed description of the new assignment of Ms. Longsworth as General Manager Trusts, as well as other changes in the company. As General Manager, she would become part of the Trust Department. It is to be noted that Ms. Longsworth's list of duties as Managing Directors contained in the 2011 contract had included her management of BTIL and BTCSL in its entirety, and her supervision of the Accounts Department, the Trust Department, and the Companies Department, as well as several other duties. Ms. Longsworth replied, questioning Mr. Wilson's ability to take over management of both companies when her primary duty as Managing Director was to manage both BTIL and BTCSL. She asked, in respect of Mr. Wilson's redesignation of her position, whether he was demoting her from her Managing Director's position. Mr. Wilson replied, indicating that he was taking over management forthwith, as was his prerogative, stating that Ms. Longsworth would still remain as a director with the same benefits. Mr. Wilson and Ms. Longsworth met on the 18th of July 2011. She told him that she felt that this was a breach of her contract because all of her duties as managing director had been taken away. His response was that her position of managing director had not been confirmed at the recent annual general meeting, that his action was not in breach of contract, and that he was entitled to make the changes. The disagreement was not resolved. Following the meeting of the 18th of July 2011, Ms. Longsworth wrote to Mr. Wilson indicating that she had sought legal advice and was advised that the actions described in the way forward amounted to a breach of her contract. She also indicated that she was not interested in the offer to be General Manager of Trusts. Mr. Wilson replied stating that it was not an offer, but rather a reassignment / redesignation. Ms. Longsworth never returned to work and the next day commenced her claim in the Supreme Court. The trial judge found that Mr. Wilson's plan of action was designed to strip Ms. Longsworth of her management of the company and went to the root of her contract. She nevertheless held that in the absence of a resolution of the Board of Directors of the company, Mr. Wilson's plan of action was merely a proposal for a redesignation from a majority shareholder, that is Mr. Wilson, and could not be attributed to the company. The trial judge felt constrained to find that Ms. Longsworth had abandoned her employment and breached her contract. The company therefore succeeded on its counterclaim. The judgment of the trial judge was overturned in the Court of Appeal. Mr. Justice of Appeal Orwich, with whom President Sosa and Mr. Justice of Appeal Morrison agreed, delivered the judgment of the Court of Appeal. The Court of Appeal held that the trial judge was correct to find that the acts of Mr. Wilson amounted to acts of constructive dismissal, but that she was wrong to find that the acts of Mr. Wilson could not be attributed to the company. Mr. Justice Allwich was of the view that the evidence before the trial judge proved that in practice, Mr. Wilson was the directing and controlling mind and will of the company and directed and controlled its affairs. Mr. Justice Morrison, delivering a concurring judgment, concluded that Mr. Wilson acted at all times in his capacity as a director and chairman of the company, and that in redesignating Ms. Longsworth's position, he was acting within the scope of his authority. Mr. Justice of Appeal Morrison was therefore of the view that by operation of the principles of agency, Mr. Wilson's actions could ordinarily be taken to be the actions of the company. The court observed that the company had not appealed the trial judge's finding that once the actions of Mr. Wilson could be attributed to the company was liable for Ms. Longsworth's constructive dismissal. But the court took advantage of the opportunity to make a few observations about the Belize Labor Amendment Act 2011, the Act. In particular, sections 39(1) and 42A, as they concern the issue of constructive dismissal. The court noted that the concept of constructive dismissal had been well recognized as part of the jurisprudence of the English-speaking Caribbean. Ms. Longsworth had relied on section 42A(1) of the Act, which provided in part that an employee was entitled to terminate the contract of employment without notice, where the employer's conduct had made it unreasonable to expect the worker to continue the employment relationship. Having considered the judgment of the Court of Appeal of England and Wales of Western Excavating against Sharp, which was referred to by the Court of Appeal of Belize, the court held the view that the legislature in Belize, by enacting section 42A(1) of the Act, had adopted the unreasonableness test, that is, conduct by the employer, which has made it unreasonable to expect the worker to continue in the employment relationship, and not the contract test applied by Lord Denning in Western Excavating. The court therefore noted that in the circumstances set out by the trial judge and accepted by the Court of Appeal, Mr. Wilson's conduct made it unreasonable to expect Ms. Longsworth to continue the employment relationship. The question therefore remained whether Mr. Wilson's conduct could be attributed to the company. On the issue of attribution, the court was of the view that it was of fundamental importance to be reminded that Ms. Longsworth's constructive dismissal claim was against BTCSL, and that her claim was based on section 42A(1) of the Act. Section 2 of the Act defined employer as including a company. As such, where the employer was a company, as in this case, it was the company's conduct as opposed to that of its agents and servants, which was required by section 42A(1) in a claim for this constructive dismissal against the company. Mr. Williams, senior counsel and counsel for BTCSL, had raised a preliminary issue before us that attribution did not arise on Ms. Longsworth's pleadings, that no argument on attribution was raised before the trial judge, and that there was no ground of appeal raised before the Court of Appeal on the issue of attribution. Accordingly, Mr. Williams contended it was improper for the Court of Appeal to have decided the case on the further submissions of the parties on the issue of attribution without inviting any further evidence or testimony on that issue. On the other hand, Mr. Courtney, senior counsel and counsel for Ms. Longsworth, contended that at paragraph 5 of a statement of claim, it was pleaded that Mr. Wilson was acting on behalf of the company and that that was sufficient to ground the issue of attribution. Counsel further pointed out that at the directions of the Court of Appeal, given some time after the appeal was heard, the parties filed submissions on the issue of attribution, and that the Court of Appeal's directions were followed without objection by attorneys for BTCSL. In those circumstances, Mr. Courtney argued, Mr. Williams's submissions were now too late to be entertained. The court agreed with Mr. Courtney. The pleadings in the case raised squarely the issue of whether Mr. Wilson's actions were taken on behalf of the company. The issue of attribution was inextricably bound up with that claim. BTCSL could therefore not have suffered any prejudice as a consequence of the directions of the Court of Appeal. In addition, the court noted that Rule 1.31 of the CCJ Appellate Jurisdiction Rules 2019 enjoined the court to ensure that unnecessary disputes over procedural matters were discouraged. As to the issue of attribution, the court considered the leading decision of the Judicial Committee of the Privy Council in Meridian Global Funds Management Limited against Securities Commission, where Lord Huffman had set out primary rules of attribution, general rules of attribution, and special rules of attribution. Primary rules of attribution were generally found in the provisions of the company's constitution, as to which official is the primary representative or organ of the company for a particular purpose. This might also be implied by company law, as for example, the rule that the unanimous decision of the shareholders was the decision of the company. General rules of attribution included rules such as the principles of agency, estoppel, or ostensible authority in contract, and vicarious liability in tort, to determine the company's rights and obligations. Special rules of attribution were rules which were applicable in exceptional circumstances, where the company's primary rules of attribution, together with the general rules, which were usually sufficient to enable determination of a company's rights and obligations, did not suffice in a particular situation. The court rejected the company's submissions that the primary rules of attribution were applicable, since Ms. Longsworth, as managing director, could only be removed or dismissed by the board of directors pursuant to Article 80 of the Articles of Association of the company. The court held that had the company invoked Article 80 and passed a resolution to dismiss or remove Ms. Longsworth as managing director pursuant to that article, there would be no issue of constructive dismissal. As Mr. Justice of Appeal Morrison had pointed out correctly in the court's view, Article 80 was applicable to cases of express act of dismissal by a company, and there was no reason to expand its area of operation beyond that. As the court noted earlier, Mr. Justice of Appeal Morrison had come to the conclusion that Mr. Wilson, as director and chairman of the company, was acting within the scope of his authority, and by the operation of the principles of agency, his actions would ordinarily be taken to be the actions of the company. While the court agreed with Mr. Justice of Appeal Morrison that Mr. Wilson was indeed an agent of the company and that liability for his actions might in certain circumstances be imputed to BTCSL, the court noted that regarding Mr. Wilson as the company's agent was very different from saying that Mr. Wilson's conduct could be identified as or treated as the conduct of BTCSL for the purpose of Section 42A1 of the Act, which makes the relevant conduct the conduct of the company. For this reason, the court was of the view that the general rules of attribution were insufficient to attribute to Mr. Wilson's conduct to BTCSL for purposes of Section 42A1. Further, the court considered that Mr. Justice of Appeal Orwich had in fact invoked the primary rules of attribution, having relied on Leonard's Carrying Company Limited against Asiatic Petroleum. Mr. Justice of Appeal Orwich concluded that Mr. Wilson, having had the management and control of the company, was the directing and controlling mind and will of the company. The wrongful acts of Mr. Wilson must be attributed to the company, and his wrongful acts became the acts of the company. The court observed that Lord Sumption, in the case of Jetivia against Bilta Limited, had expressed the view that where the directing organ of the company expressly or implicitly delegated the entire conduct of its business to the relevant agent, who is actually, although not constitutionally, its directing mind and will for all purposes, such a person stood in the same position as the board, as was the case in Leonard's. The court noted, however, that all the other law lords in Jetivia, either expressly or by necessary implication, rejected Lord Sumption's view of the law. Lord Mance categorized Leonard's as a case that was decided on a special rule of attribution fashioned for the purposes of Section 502 of the Merchant Shipping Act of 1894. Lord Newburger, Lord Clark, and Lord Conworth, by necessary implication, agreed with Lord Mance's categorization of Leonard's. Finally, Lord Toulson and Lord Hodge treated Leonard's as an example of the operation of the special rule of attribution in a statutory context. Having concluded that neither the primary nor the general rules of attribution were applicable, the court considered whether it ought to fashion a special rule of attribution as it relates to Section 42A1 of the Act. The court noted that the clear law that emerged from the judgment of Lord Hoffman in Meridian Global Funds and the majority of the law lords in Jetivia was that where a claim was based on a particular statutory provision, as in this case under Section 42A1 of the Act, the court must fashion a special rule of attribution for that statutory provision. This was a matter of interpretation of the statutory provision. The key question was, given that Section 42A1 of the Act was expressly intended to apply to a company, how was it intended to apply, and whose conduct was, for the purposes of that section, intended to count as the conduct of the company. Following the opinion of Lord Hoffman in Meridian Global Funds, the answer to this question was to be found by applying the usual canons of interpretation to Section 42A1, taking account of the language of that section and its context and policy. To be sure, the court noted, as with any question of attribution, the key under the special rule of attribution in this case was ultimately always to be found in considerations of context and purpose of Section 42A1. In the judgment of the court, the context and purpose of the Act and of Section 42A1 were clear, recognizing that in Belize, as in most modern market economies, a substantial proportion of the workforce was employed under contracts with companies incorporated under the Companies Act. The court observed that the section sought to make such companies directly liable for constructive dismissal. The court further recognized that such companies were no longer characterized by vertical corporate structures, but by the diffusion of responsibility and delegation of important corporate tasks. The unmistakable purpose of Section 42A1 was to merge the liability of a company with an identifiable official of the company. Thus, contrary to the assumption of Mr. Justice of Appeal Orwich, there was no need to determine whether such an official was or was not the controlling mind and will of the company for purposes of Section 42A1. The court was of the view that the facts of this case made it plain that Mr. Wilson was undoubtedly an identifiable official of BTCSL whose conduct may be merged with BTCSL. A consideration of the emails referred to earlier and the dealings of the company going back to its inception made clear that Mr. Wilson had been acting for on behalf of the company. This included the company's dealings with Ms. Longsworth. In our judgment, therefore, the special rules of attribution were applicable in this case. Considering all the circumstances, the conduct of Mr. Wilson was taken to be the conduct of BTCSL for purposes of Section 42A1. The court therefore made the following order. The appeal is dismissed and the judgment of the Court of Appeal is affirmed. The appellant shall pay to the respondent costs of this appeal, certified fit for 2 attorneys, and to be taxed in default of agreement. Thank you very much, Mr. President.
Thank you very much, Madam Justice Rajnath Lee. And of course, that summary is not the judgment of the court and is not to be expressed as the judgment of the court. The judgment of the court is a formal document which has been distributed and will be put up on our website. This is just a summary. Is there anything from council? No?
No, Your
In that-
Honor.
No, Lord President.
Yes. In that case, I thank you very much for your attendance this morning, and the court now stands adjourned. Thank you.
Thank you too.